Hello viewers, Namaskar. I am Professor Vageshwari Deswal, a professor at Faculty of Law, University of Delhi. We are doing a series on new criminal laws. In this session, we will be dealing with the changes that have been brought about in the law relating to hurt, grievous hurt and acid attacks. So, first of all, let us understand how we have managed to compress our BNS in 338 sections from 511 sections that were there in the Indian Penal Code. That is because we have made our new law shorter and crisper, unnecessarily putting the same content in sections over and over again. That has been avoided. And so that is how what we have done is, that is when we talk about the chapter that deals with offences affecting the human body, and in that when we talk about the crime of hurt and grievous hurt, it was earlier covered under sections 319 to 338 in the Indian Penal Code. Now, it has all been contained in 11 sections starting from section 114 to 124 of the BNS. So, first that it defines what is hurt, what is grievous hurt, thereafter what constitutes voluntarily causing hurt and voluntarily causing grievous hurt. Thereafter, in one single section, that is section 118, we have defined what constitutes voluntarily causing hurt or grievous hurt by dangerous weapons or means. Now, in the old penal code, this was covered under two sections, that was sections 324 and section 326 of the Indian Penal Code. Now, whoever employs dangerous weapons or means to inflict any kind of a hurt, whether that amounts to simple hurt or whether that is grievous hurt, now there is a single provision, section 118, that takes care of that. Similarly, earlier we had two sections, sections 327 and 329, which dealt with voluntarily causing hurt, and another one was voluntarily causing grievous hurt to extort property or constrain to an illegal act. Now, whether it is causing of hurt or whether it is causing of grievous hurt, but when it is done with an objective to extort property or to constrain to an illegal act, they are both covered under one single provision, that is section 119 of the Bharatiya Nyaya Sanhita. Similarly, section 120, this deals with voluntarily causing hurt or grievous hurt to extort confession or to compel restoration of property. This was earlier covered under two sections, that was section 330 and section 331. So, you see that the same content was being repeated with one simple difference, that is, in one instance hurt was being caused and in another instance grievous hurt was being caused, but the objective was the same. So, now depending upon the objective, irrespective of the hurt that is caused, there is one single provision and it prescribes separate punishments depending upon the consequences and the intention of the offender. Similarly, section 121 of the BNS, it deals with voluntarily causing hurt or grievous hurt to deter public servant from his duty. Now, this was earlier covered under two sections, that were section 332 and section 333 of the Indian Penal Code. Then, section 122, which deals with voluntarily causing hurt or grievous hurt on provocation. See viewers, provocation, when it is grave, when it is sudden, it serves to mitigate the liability of the accused person. See, the accused is still to be held guilty because he has voluntarily caused hurt or a grievous hurt, but the liability is reduced. Why? Because had it not been for the provocation that came from the other side, this accused person would not have caused hurt or grievous hurt. So, because it is the act of the other party that has put this accused person also in this position, that is why it serves as a mitigating factor. So, earlier we had covered this in sections 334 and 335 of the Indian Penal Code. Now, it is section 122 which deals with that. Similarly, section 123, which deals with causing hurt by means of poison etc. with intent to commit an offence, has replaced the old section 328 of the Indian Penal Code. And wrongful restraint and wrongful confinement that were earlier spread over a large number of sections, starting from sections 339 till section 348 of the Indian Penal Code, now that has all been included in merely 2 sections. Section 126 of the BNS deals with wrongful restraint and section 127 deals with wrongful confinement. So, now let us see how the definition of grievous hurt, which was earlier given under section 320 of IPC, has undergone a change now under section 116 of the BNS. So, by and large the definition is the same. It says the following kinds of hurt only are designated as grievous, namely, first is emasculation, second is permanent privation of the sight of either eye, C, permanent privation of the hearing of either ear, fourth, privation of any member or joint, then destruction or permanent impairing of the powers of any member or joint, then permanent disfiguration of the head or face, then fracture or dislocation of a bone or a tooth. So, these 7 clauses are the same. The change that has been brought about is in the clause 8thly, that is H, which says any hurt which endangers life or which causes the sufferer to be during the space of 15 days in severe bodily pain or unable to follow his ordinary pursuits. So, now how has the law changed? Earlier this was 20 days. Now what it requires is that the person should be in severe bodily pain for 15 days so as to be unable to follow his or her ordinary pursuits. Now why has this been done? See, modern science has enabled now faster diagnosis, we have better medicines, now we can replace knee joints, hip joints, even severed fingers can be stitched back, ligament tears can be repaired. Now we can have surgery with minimal cuts or invasions. Laser, it enables the most complicated procedures to be done within a fraction of seconds. See, modern pain medicines and anesthesia, they can control pain and they can help your body heal. So, for these reasons, the period that was provided for the sufferer experiencing severe bodily pain for the purpose of grievous hurt, now this has been reduced from 20 days to 15 days. Then, coming to voluntarily causing grievous hurt, so under section 117, 2 subsections they have been changed. One is subsection 3, one is subsection 4. What it says, 117 subsection 3, whoever commits an offence under subsection 1 and in the course of such commission causes any hurt to a person which causes that person to be in a permanent disability or in a persistent vegetative state. So, you see, earlier we did not have these provisions, that is, if the victim is rendered in a persistent vegetative state, then what would happen? See, in such cases what would happen? If the victim doesn't succumb to his injuries, so if the person doesn't die, we cannot impose charges under culpable homicide, and the punishment that has been prescribed for grievous hurt would appear very less in comparison to a person who has suffered such injuries that have caused the person to be in a persistent vegetative state. So, in order to address those kind of problems, now there has been this change that has been introduced in this law, and what it says that in such cases the accused shall be punished with rigorous imprisonment, and the rigorous imprisonment shall not be for less than 10 years. So, we have introduced minimum punishment in such cases, but which may extend to imprisonment for life and which shall mean imprisonment for the remainder of that person's natural life. So, what that means is the discretion which vested in the Home Department to commute the sentence of life imprisonment to say 14 years, now that has been taken away in such cases, and if the accused has been awarded with imprisonment for life and it has further been qualified to mean imprisonment for the remainder of that person's natural life, then the person would have to spend the remaining part of his natural life in the prison. Then section 117 subsection 4, it says when a group of 5 or more persons acting in concert causes grievous hurt to a person on the ground of his race, caste, community, sex, place of birth, language, personal belief or any other similar ground. So, here what is required is that the victim should have suffered some kind of a grievous hurt, and the grievous hurt should have been inflicted by a group of people who should be minimum 5 in number, and those 5 people, they should have been acting in concert. That is, there has to be some sort of a prior planning between these 5 people. And when they have inflicted grievous hurt on a person, and the reason was, what was the motivation? Why did they injure the person to an extent that he suffered a grievous injury was? The motivation here could be ground of race, caste, community, sex, place of birth, language, personal belief or any other similar ground. So, you see, where there is a mob that is out to lynch a person, where it is a case of a hate crime, when people, they are being targeted on grounds of honor, but what happens when they do not kill the other person, but they have injured the person in a grievous manner, then in such cases, what is the punishment? The law says each member of such group shall be guilty of the offence of causing grievous hurt. So, now there is a joint liability irrespective of the part that was played by either one of them. So, the law says each member of such group shall be guilty of the offence of causing grievous hurt and shall be punished with imprisonment of either description. It could be simple imprisonment, it could be rigorous imprisonment, but the imprisonment shall be for a term which may extend to 7 years and additionally shall also be liable to fine. So, now the law has been made very strict. And why was it required? See, suppose a person is subjected to a grievous hurt which renders him in a persistent vegetative state. So, a persistent vegetative state, it is also known as post-coma unresponsiveness. Now, this is a chronic disorder in which an individual with severe brain damage appears to be awake, but that person shows no evidence that they are aware of their surroundings. So, sometimes people who are in persistent vegetative states, they might open their eyes, they might at regular intervals sometimes wake up, then again slip into sleep. They might also exhibit certain basic reflexes, such as they might blink when they are startled by a loud noise, or sometimes when you squeeze their hands in a very hard manner, they might try to withdraw their hands. See, although some patients, they regain their awareness after more than 4 or 5 months in a vegetative state, but it is very depressing that it's only a few people who recover. Most of the time, people, they keep waiting for a miracle to happen. and people may over the years sometimes achieve an improved quality of life, but that is within the limitations of their disabilities. So in such cases, their recovery period is prolonged and it may continue for several years. So in such cases, we have now prescribed an enhanced punishment. Now moving on to the next provision, which is section 125, that is act endangering the life or personal safety of others. Now this is a provision which was covered in 3 sections in the Indian Penal Code. There was section 336, 337 and 338 which dealt with this single act. Now this is an act which is so rash and negligent that it endangers the safety of others. So now what have we done? We have increased the amount of fine. The law says whoever does any act so rashly or negligently. So what is rashness and negligence? Negligence is want of due care and precaution, and rashness is mental indifference to an obvious risk. See, there is a basic degree of care and precaution that every person is supposed to exercise while doing any act. But if you've acted in a rash or a negligent manner and the law says that you've done an act so rashly or negligently as to endanger human life or the personal safety of others, then such a person shall be punished with imprisonment of either description for a term which may extend to 3 months or with fine which may extend to 2,500 rupees or with both. But in such cases where hurt is caused, so you see, if you've acted in a rash and negligent manner so as to endanger life or safety of others and it doesn't result into any consequences, still you can be punished up to 3 months and 2,500 fine. But where hurt is caused as a consequence of such rash or negligent act, then the accused shall be punished with imprisonment of either description for a term which may extend to 6 months or with fine which may extend to 5,000 rupees or with both. So now the amount of fine that has been increased, moreover, where grievous hurt is caused as a consequence of such rash or negligent act, then the punishment would be imprisonment of either description for a term which may extend to 3 years or with fine which may extend to 10,000 rupees. So here even the term of imprisonment has been increased and the fine has also been increased to 10,000 rupees, and also it says the person can be punished with both. That is, the person can be asked to be imprisoned and additionally may also be required to deposit the fine. Now coming to section 124 which deals with acid attacks. Earlier in 2013, when the Criminal Laws Amendment Act of 2013 had introduced 2 specific provisions in the IPC, they were section 326A and section 326B of the IPC. Now under BNS, these both have been clubbed together and placed in one single section, which is section 124 of the BNS. Now, it says voluntarily causing grievous hurt by use of acid, etc. See, we all know what are acids, but why have the lawmakers chosen to use the term etc.? See, I'll tell you why. Acid is an element or compound that has a pH base of less than 7. For example, we can talk about HCl, which is hydrochloric acid, or H2SO4, which is sulfuric acid. Then when we talk about this term etc., this is because in criminal laws what happens, we construe the law very strictly. What happens because of that? That unless and until the act of the accused falls squarely within the definition that has been laid down by the lawmakers, the accused gets the benefit. So that is why we have to ensure that when a person is injured in a grievous manner and what has been used against such person is any corrosive substance. So it is not only acids that are corrosive in nature, sometimes alkalis are also very corrosive. See, what is an alkali? It's a matter of substance that is also called the basis with a specific pH of more than 7. It can be corrosive, for example, bleach, ammonium hydroxide, sodium hydroxide. So, if the lawmakers had titled the provision as just causing voluntarily causing grievous hurt by use of acid and they had omitted the term etc., then what would happen? An accused would use alkalis and then he would argue before the courts that, see, I have caused the injury but not by means of acid, and it is only acid which is punishable under section 124. So, in order to do away with these kind of confusions, in order to stop these kind of escape routes of the accused persons, the law says when grievous hurt has been caused, it could be caused by use of acid, etc. So, it could be like some other corrosive substances also. So, you see, just like concentrated acids, concentrated alkalis are also corrosive. They can attack and destroy skin if spilled. Concentrated alkalis are just as concentrated, are just as dangerous as concentrated acids, and both they result in chemical burns. Sometimes alkalis can cause deeper burns. There are some metallic alkalis that are highly reactive with water, and see, what is the normal reaction? If acid is thrown on someone else, usually the bystanders will throw water on that person, or that person might himself or herself also try to locate some nearby water source so as to wash off the acids. But where the victim is not aware that what has been thrown on the victim is not an acid but an alkali, and sometimes because alkalis, they are highly reactive with water, what happens in such cases? It can cause the burn to worsen. There are certain alkalis such as metallic lithium, sodium, potassium or magnesium which should not be washed away with water. These should be first brushed off and only then can we think of some other recourse. So, section 124, subsection 1, it says, whoever causes permanent or partial damage or deformity to, or burns or maims or disfigures or disables any part or parts of the body of a person, or causes grievous hurt by throwing acid or by administering acid to that person, or by using any other means with the intention of causing or with the knowledge that he is likely to cause such injury or hurt, or causes a person to be in a permanent vegetative state, shall be punished with imprisonment of either description for a term which shall not be less than 10 years, but which may extend to imprisonment for life. So, when somebody is attacked with acid and that causes a grievous hurt, or if that causes a person to be in a permanent vegetative state, then the imprisonment shall not be less than 10 years. And then there is also a fine, and what the law says, provided that such fine shall be just and reasonable to meet the medical expenses of the treatment of the victim. Provided further that any fine imposed under the subsection shall be paid to the victim. See, ordinarily fine under criminal laws, it goes to the state, but when we are talking about imposition of fine in cases of acid attacks, this has to go to the victim. Section 395 of the Bharatiya Nagarik Suraksha Sanhita deals with order to pay compensation, and it says when a court imposes a sentence of fine or a sentence including a sentence of death of which fine forms a part, the court may, when passing judgment, order the whole or any part of the fine recovered to be applied in defraying the expenses properly incurred in the prosecution and in the payment to any person of compensation for any loss or injury that is caused by the offence when compensation is, in the opinion of the court, recoverable by such person in a civil court. Then section 396 of BNSS deals with victim compensation scheme, which was there in section 357A of the CRPC, And subsection 7 says the compensation payable by state government under this section shall be in addition to the payment of fine to the victim under section 65, section 70 and subsection 1 of section 124 of the BNS 2023. Then section 124 subsection 2 deals with attempt to throw acid. So, you see, even where the accused is not successful, but when it has been attempted to attack the person with acid and the intention was to cause any kind of a permanent or partial damage or deformity or burns, then in such cases also the punishment shall not be less than 5 years and it may extend to 7 years and also fine. So, here they have further clarified that acid would include any kind of a corrosive substance and permanent or partial damage or deformity or permanent vegetative state shall not be required to be irreversible, because as we have already discussed, because of medical advancements now people they can expect recovery. Section 397 of BNSS deals with treatment to victims and it says that all hospitals, whether public, private, central government, state government, local bodies, now they are all supposed to provide mandatory first aid treatment to such victims. It has to be provided free of cost and also information has to be given to the police. This was all for this session. There were a couple of cases such as Makbul versus State of UP, in which there was a simple question of determination, that is what would happen if in acid attack the injury is simple. So, what the court said that, see, statutes should be construed. So, in such cases we cannot add anything more to the law. So, it is not the percentage or gravity of injury which make the difference, whether it is simple or grievous. If the injury falls under the specified types under acid attack as is given therein, then the law would be attracted. Okay. So, viewers, this will be all for now. Thank you. Jai Hind.